attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a LawCast series talking about the SEC investigation and public statements on initial cryptocurrency offerings, also known as ICOs. On July 25, 2017, the SEC issued a report on an investigation related to an initial coin offering called ICO by the DAO and statements by the divisions of corporation finance and enforcement related to the investigative report. On the same day, the SEC issued an Investor Bulletin related to ICOs. In short, the offers and sales of digital coins, cryptocurrencies, or tokens using distributed ledger technology, or DLT, or blockchain have become widely known as ICOs. In a prior LawCast series, I introduced the topic of DLT and blockchain. The basis of the SEC report is that offers and sales of digital assets, including cryptocurrencies, are subject to the federal and state securities laws. From the highest level, the nature of a digital asset must be examined to determine if it meets the definition of a security using established principles, and in particular, the Howey Test. All offers and sales of securities must either be registered with the SEC or there must be an available exemption from such registration. This statement applies to cryptocurrency securities in the same manner it applies to all other securities. In addition, participants in ICOs are subject to federal securities laws to the same extent that they are in other securities offerings, including broker-dealer registration requirements. Securities exchanges providing for the trading of cryptocurrencies must register unless an exemption applies. Despite the SEC findings, it declined to pursue an enforcement action against the DAO, but rather used the opportunity to inform the public on its views, and in particular that the federal securities laws apply to those who offer and sell securities in the United States, regardless whether the issuing entity is a traditional company or a decentralized autonomous organization, regardless whether those securities are purchased using US dollars or virtual currencies, and regardless whether they are distributed in certificated form or through distributed ledger technology. In the press release announcing the investigative findings, SEC Chair Jay Clayton stated, "The SEC is studying the effects of distributed ledger and other innovative technologies and encourages market participants to engage with us. We seek to foster innovative and beneficial ways to raise capital while ensuring, first and foremost, that investors and our markets are protected." This is not the first time the SEC has addressed registration and exemption requirements associated with cryptocurrencies. There have been several other cases. For example, in December 2014, the SEC settled charges against BTC Virtual Stock Exchange and LTC Global Virtual Stock Exchange related to violations of both the broker-dealer registration requirements and the securities offering and sale registration requirements. This LawCast series will summarize the SEC report of its investigation, the statements of the divisions of corporation finance and enforcement, and the Investor Bulletin on initial coin offerings. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.